Sach Oliver is a distinguished trial lawyer focused on catastrophic trucking accidents and is the CEO of the Oliver Law Firm and is renowned for his expertise in the courtroom. With over 20 years of trial work, he stands as one of the top trial lawyers in the United States. His commitment extends beyond depositions and trials, as demonstrated by his his work as a passionate live auctioneer, where he has raised millions of dollars for nonprofit organizations, showcasing his dedication to making a positive impact. His inaugural publication, Depositions Are Trial, published by the AAJ, the American Association for Justice, just hit the shelves, where he shares his expertise, results, and battle scars across the country. And now let's get started.
Bill, thank you very much. Honored, humbled to be with you here today, and I look forward to visiting with you for the next hour or so. We're going to talk about depositions and our philosophy and methodology. Depositions are the trial. And this is something, we've written a book about it. It's a methodology that we have been applying for probably 15 years now, and it works extremely well. We're going to walk through some of that today. I do welcome questions. They've told me those need to be at the end of the session today. And I look forward to hearing any questions that you have. So basically, I'm asking you to open up your mind to a new way of thinking. That your next deposition is not a discovery deposition per se, like maybe you were taught in law school, like I was. It's not a deposition to just find out the who, what, where, or why. But in today's modern trial litigation culture, your next deposition, it is the trial. And with today's post-pandemic jury situation, we're seeing 50% of witnesses in almost every trial that are by video. And some more than that, depends on what jurisdiction we're in, of course. We travel all over the country and try cases in everywhere. So we have to adapt to the different local rules and jurisdictions and judges. But still yet, our last case in Oregon, our last case in California, and our last case in Arkansas, those are all three extremes, jurisdictional. 50% of the witnesses were by video. And so before the pandemic, our philosophy, depositions are the trial, it was a philosophy. Now it's literal because of the pandemic. And so most likely the video, 50% of the video depositions that you take, it's going to be what's shown to the jury. So what are you going to do with it? Because if it's not trial preparation testimony, it'll fall short and it'll be lacking, or at least it will be compared to ours. And so I ask you to open up your mind to a new way of thinking. And it's really simple. It's no longer a conference room in today's litigation environment. Now, keep in mind, we specialize in 18-wheeler cases. That's what we do. We do handle the occasional construction case, whether or not it's a construction zone or a construction failure at a facility or a nuclear plant. But most of our cases are 18-wheeler cases. We exclusively represent the plaintiffs. And to give some context, we have currently 18 cases across the country, and they are significant and large cases. So I want you to have that context. So we see the conference room as the courtroom. It's not the conference room. And so we're going to put the amount of preparation necessary to get organized from our strategy, through our visual aids, through our exhibits, through our cadence, through our questions, to be ready for trial. We see the world when it comes to depositions as a series of deposition video clips. That's how I see it. We have to collect the truth, put an exhibit or visual aid with it so that it's all really enjoyable by the judge and the jury. And then we have to play these video clips in 15, 30, 60, 90-second video clips to our jury at trial. Well, that means all of the work has got to be done before the deposition takes place. And that's our philosophy. So here's an example. Here's a tractor trailer case in Ohio, and it's R&L Carriers, the corporate representative. This is deposition. This deposition was taken at a very, very nice defense firm up tall, high in the building, a skyscraper deal. And I just show you this to give you an example that we're going to get there way early to set up. And our organization, there's nothing fancy about it, but let's see if this video will play. If not, I may have to ask.
Ready for the deposition today of corporate representative of R&L Carriers. I've already met him this morning. Pleasant man. He'll sit right here. Deposition outline. Computer for videos that we're going to play. Binder 1 with exhibits ready for trial. Clipboard, just like we're going to do at trial. An actual calendar, trucking calendar. We can fill in dates. Previous depositions provided by great friends in the trucking industry. Rulers, and of course every exhibit and visual aid for trial. Binders 1 through 7, organized and ready to go.
So in this particular setup, which we can see a pattern of in our depositions, it's pretty simple. But if we have the witness, wherever the witness is placed in this situation, they're on the end of this long table, and the videographer eventually will be at the far end of the table. We have our deposition outline, every question typed out, and those questions are sequenced. We'll talk about the sequence of that in just a moment. And the questions are sequenced in order with our exhibits and our visual aids that are in the binders that you see. And in this case, there was 136 exhibits and visual aids in those 7 binders. And so they are all in precise order so that we have rhythm and we have flow and we are organized. And of course, we have our toys with us, like drawing, rulers, coloring pens, Sharpies, so the witnesses can draw exhibits and visual aids as it occurs. We also have our laptop set up, not for us. My goodness, not for us. The laptop is for the witness to show the witness blow-ups, visual aids, exhibits, dash cam footage, crash recreation. We have a policy in our office that we do not use our laptops during the deposition. We don't type on our laptops during the deposition. It's about the most insulting thing you could do to the witness, either your client or the adversary, is to be over there typing, working on something else, or much less is what I've seen so often, someone reading the news with a sports page. Because let me just tell you this and just be honest and blunt. Whenever I'm deposing a vice president, corporate representative, usually they're a highly paid executive, a highly functioning, high capacity individual, and we're focused and we're attuned and we're in line, and we're active listening, and we're rolling through this. When I see that there's 3 defense lawyers, in my case, sitting on the other side, every one of them have their laptop in front of them, and you just can't help but pick up that, they're reading the news with a sports page. I say hallelujah, glory to the good Lord, because the witness also picks up on it. He's offended by it, and he tunes in more to me as well. And so I always call it telltale signs. I always have a telltale sign. That's one of them, where we're going to annihilate the other side whenever they're checking the sports while their corporate representative is being deposed by our team members. So you just go through there and you see these things, and you can see also I've removed most of the chairs from my side of the table. That's so I can move freely about the courtroom. We're going to stand up. I'll show you some examples of that shortly. We'll stand up during the deposition and move freely about the courtroom, approach the witness, show exhibits. And I don't have them here, but we often will have our big boards, 3x4 foam boards with blow-ups with us at the deposition as well. One reason our depositions have been successful in our methodology of depositions are the trial are successful is that we consider the deposition process to be a journey with the jury. We have done the jury research, test, and test again, way before we took the depositions in the case. We're generally going to do a case acceptance focus group before we've accepted the case or right at the beginning of the case. And it's going to do general issue spotting of what we know about the case at that preliminary stage. Then we're going to conduct the rounds of investigation and discovery, collect evidence, mad factors, dirt, etc. And then we'll test it again. A lot of times, about a midway through the deposition process, we'll do another focus group test. Then once we've collected all the evidence and done the full investigation, taken the depositions, we'll do a full-blown mock trial, or I call it jury simulation, where we will, most recently, we've been, in the last 5 years, I've been hiring outside defense counsel to actually prepare the defense. And I try to get someone with an equal or more experience. So if my defense lawyer has 35 years of experience in the tractor trailer defense industry, I'm going to try to find a defense lawyer with 35 years experience in the tractor trailer industry to do it, or 15 years or 20 as well, so that we can adequately test the case truly, because you're about to find out, we're going to find out our vulnerabilities from the very beginning all the way through the case and be ready for it at deposition. And that's because we want to know what our side's landmines are before the deposition takes place. That level of intellect and testing and strategy will give you the upper hand during the deposition, just like it does at trial. That's why they're one and the same anymore. I've got a great example here why focus groups are so important. I had a tractor trailer case where the truck driver was watching pornography, and obviously I thought that was a huge mad factor. So we tested it before any deposition started on a focus group. We did look at these visual aids we created, even the morning porno clock, focus group, and all that kind of stuff. And the focus group came back and said I was committing character assassination. And matter of fact, it was an extremely conservative venue. And in my mind, this is why focus groups are so important, is I'm generally wrong. In my mind, that conservative Bible Belt venue, the porno clock visual aid would have driven damages, right? Driven punitive damages, driven culpability, driven everything. However, I was wrong. We found out that the jury, focus group jury, believed I was committing character assassination. And so we realized that we needed to change and alter how we approach that. So we literally converted, after this focus group, they ripped my head off, that we converted it to watching something. Didn't mention the word porn, didn't say what they were watching, and took away all those X's and whatnot. We simply said the driver is watching something. It absolutely, then we tested the case again, and it achieved what we wanted. We're telling the truth. Now the jury was very upset at the truck driver, did not have any backlash blow at us for character assassination whatsoever. And quite honestly, it got better, because as we tested it, the jurors' imaginations about what they were watching, they plugged in what they perceived to be the worst case scenario. So in that particular case, the defense filed a huge motion in limine to exclude pornography, and we negotiated an exchange where we didn't want them to do something. In exchange, we would not say pornography. And of course, they gladly agreed to it because they had not done their own focus group research and knew that we weren't even going to do it anyway. Mad factor testing. We want to know the sequencing of the mad factor evidence, what upsets the jury the most before our deposition. Why is that? Remember, I talked about sequencing. We want to sequence our deposition outline as the same as our mad factors. So if we have a case where the truck driver is a convicted felon within 3 years of hire, he was on his cell phone and he tested positive for methamphetamines, and he's speeding into a construction zone. 4 mad factors, see? Now, every time I plug it into my head as to what the number one mad factor is, I always enjoy testing it. My office likes to kind of take bets even, because I'm always wrong. I want to hear what the focus group has to say is, of those 4, what's the most upsetting piece of evidence to the jury? And you know what we find? It's almost always unanimous. That's crazy. The number one mad factor is almost always unanimous. And that's if I've got 12 people, 72 people, or our last jury simulation, we brought in 144 people in Albuquerque, New Mexico. And the number one MAG factor, it was not quite unanimous. Over 130 people had the same exact MAG factor. That's kind of crazy. And so that's how important it is to know. And of course, we use this sequencing throughout the rest of our trial preparation, but we're talking about depositions on trial today. Focus groups, jury simulations, and then of course, dress rehearsals. Your dress rehearsal for a trial, which we do standard 2 weeks before the trial starts, we have all of the witnesses by video clip. Even the witnesses that are going to testify live at trial, we still have their video clips. Our dress rehearsals are the closest thing that you can get to the real trial because of our depositions, our trial methodology. It works very well. And of course, if we're doing focus groups and we're standing in front of people, we're testing it out, we're then applying it with the depositions, our trial methodology, then we're doing jury simulations where we're testing the case adversarially, and then we're doing dress rehearsals, you're ready for trial. I mean, this methodology works so well and it flows. But I will tell you that our cases and our depositions, our trial methodology is so visual aid heavy that visual aids must become the culture of the case. I've seen so many, and I used to do it this way, 20 years ago. I used to make up a visual aid at the last second, or if the case didn't settle at mediation, oh my gosh, we got to create our visual aids for trial. I will suggest to you that's the old way of doing it. That the way to do it now is we want those visual aids done way before the deposition, and we're using those visual aids in the depositions with the witnesses. Now, that is a work in progress. Most of our visual aids are spot on. They work very well. But if you're using them with witnesses, if it's the truck driver, safety personnel, engineer, mechanic, executive, corporate representative, and they don't like something about a visual aid, I'm going to hand them the Sharpie to let them fix it. And I love that organic part of the deposition, our trial, just like we were in front of the jury, and they use their Sharpie to fix it. We capture it all on video, and then we use the visual aid that's corrected with a Sharpie by that witness, either by video or in front of the jury live. If you want to consider making visual aids the culture of your case, then you want to bring them into the pleadings. Our pleadings have visual aids built into the complaint package, built into the trial briefs, built into motions filed, built into motions for summary judgments filed, or responses in our case generally to partial motions for summary judgment. So that from the very beginning, everyone in the case, opposing counsel, the judge and their staff, insurance committees reviewing it, of course, our clients as well, everybody is gradually becoming accustomed to using and seeing and touching and being a part of our visual aids. We also, when we send letters, just routine letters in the case, let's say one of our cases, let's say the average turnaround of one of our cases is 18 months to 2 years. And how many letters do we send to opposing counsel or the court in that time period? 30, 50, 75? Well, we're going to put the visual aid that assists in whatever the content of the letter into the letter. So even our letters have got this culture rolling through it. And of course, scheduling hearings by Zoom or in person, we're going to show visual aids, all of our depositions, motion and discovery hearings. Of course, the mediation is going to have a tremendous amount of visual aids. We have a mediation next week, a 2-day mediation in Fort Worth, Texas. And 60 days before the mediation, we send an entire full cards up deposition video clips presentation with all of our visual aids for trial to the insurance tower, just so they've got all our visual aids No secrets there because we used every one of those visual aids in the 13 depositions of the case. Of course, pretrial hearings and trial. So if you're using these visual aids like this, and if you start doing it gradually, if you've never done this before, just get started. That's what I would say. Just start. Use one visual aid, use 3. The next thing I hear a lot is, oh my gosh, Sach, you've got 20 cases. I've got 150 cases. Well, don't try to do all this on 150 cases, but you can start on 3 cases. So pick what you believe or perceive to be either your favorite or your best, whatever you want to go about doing. 3 cases and start this process of using visual aids. I will tell you what invented this idea is failure, because as you probably know, the rules in your great state, rules in my great state, anywhere I go, visual aids can be created in front of the jury. You can draw right there in front of the jury. Visual aids that are used for demonstrative aid purposes to assist the jury can be created by the rules at the last second, the night before. However, I have found judge after judge after judge who have just taken a position that if you haven't shown it to the other side in a timely manner, the presumption is they're not going to let me use it. And I had 2 or 3 trials in a row as a young buck where that happened to me. And I said, never again. These are great creative visual aids. They deliver the point. They tell the truth. The jury deserves to know about them. And all I had to do was use them throughout the case, give them to the other side often and early, show them to the judge at the hearings, and I could have used them. It was a simple decision for us. And so while it started out many years ago through failure, it has become something that plaintiffs' lawyers are adopting across the country. And I just love to get the feedback. Lawyers are sending me videos of their visual aids and how they're using them. And it's fantastic. I'm thankful that it's working for so many people. Visual aids are a creative process. I just got asked to speak at the Chicago Big Truck Auto for the National Trial Lawyers Association on visual aids because our visual aids are so effective. And I told them what I'll tell you. Visual aids have got to tell a story. And the more of an emotional story that they tell, the better. The next thing everybody's like, oh man, why do your visual aids work? It's because we only want the truth on there. I hear lawyers say, oh man, I got to come up with a trick. I got a problem with my case. I got to come up with a trick visual aid. If you're trying to trick somebody with a visual aid, I call that a defense verdict or a low verdict. And so let's not try to trick anybody. The reason why our visual aids work so well is that they're the absolute truth and they tell a story. And I hope they're emotional, but they're creative. And we get them out and show them often. We want our visual story to tell the 5 senses somehow. Get those 5 senses out there. Now, you got to be creative to do this in depositions. You got to, obviously sight's easy. They're going to see all kinds of stuff. Touch, we're going to pass things around to the jury. Fishing poles of the decedent, teddy bears of the decedent, favorite artwork of the injured. Whatever that is, we're passing it around. Exhibits, of course, we're going to pass around. So we can do touch. We can do hearing. Now, smell, we have to get creative. But how do we do that? Well, you got to think it through. But it's like our book, Depositions, Our Trial. I wanted it to serve as the 5 senses, the book itself. So I reached out to Nestle, had them duplicate our little cover of our book and create our Hershey's bar so that when you buy the book, you get a Hershey's bar so it has the taste. And then, of course, we wanted to smell like leather, so we inserted leather senses into the book. And then when you open the cover of the book, just like you see those Hallmark cards to tell you something, when you open the cover of our book, it makes the sound of a horse neighing. And so our book even covers the 5 senses. Now you got to be creative to think that through, just like in your trials. So screeching sounds, if we have a case where the tires are screeching, that's a sound that we can duplicate often. If we're trying to do different sounds like that. Now, what about smell? Well, I will tell you the most effective smells situation is a burning case. We had clients that got burned up. And so the witnesses and the clients were talking about the smell of a burning body. And you take cowhide of some sort and you can burn it and have it described. And that's what our clients went through as their body was being burned. That's an example. Taste. You have the taste things such as, well, burning is a great one because if you've ever represented a burn client, they talk about the black licorice taste in their mouth that comes back to them at all times. And so we're going to pass out black licorice to the jury. We're going to ask the judge and the jury if they'd be able to take a bite of it to experience even in a minor way and know what it's like to get this feel. Even if nobody takes a bite, which they don't take a bite, and judges don't want me to let them. The black licorice is used as a visual aid, and everybody has taken a bite of black licorice, and so they know that taste. So I'm telling you, our visual aids, we're getting creative, but we want them to be the 5 senses. Let's see. Where are we going to take our deposition? Here's a first responder of a client that's cut out after a tractor trailer case in a construction zone.
And then the cutters that you said were like giant scissors. Just like a giant crab claw, basically.
Yes, sir.
Pinches it. Okay. And then that was the one you said you tried using that and it wasn't working because it was twisting it too much?
It was torquing that pedal into the blade more.
Okay.
So that's a great example. We're doing the first responders who have to use the jaws and the hydraulics and the sawzalls to cut our client out. And so instead of doing that in a lawyer's conference room or even the firehouse had a conference room, we did the deposition in the garage, in the fire truck. And so he demonstrated the tools and got them out. He actually cut some metal that was like what was used to cut out our client from the RV. And so we use that as an example. Now, in that particular case, why do you do all that? Well, one, we want to have it on video clip. I've had bad luck getting judges to let me bring fire trucks into the courthouse or even big, huge jaws of life. They tell me, go get your evidence some other way. This judge was a wonderful judge and she ordered it to come into the courtroom. And so, hallelujah, we had the best of both worlds. I get to tell you that story and we got to bring in the real stuff into the courtroom, but we did have that video clip in case something as a backup plan went wrong. Okay, depositions, your toys, these video clips are trial. Get your toys ready. Almost every one of our cases, I'm sure there's some exceptions, but it's been a long time. Almost every one of our cases, we can find toys on the internet that duplicate or are substantially similar to our fact pattern, right? We buy those toys, we recreate scenes all the time, and it is very effective with juries. Matter of fact, we have tested toys, recreations, versus crash reconstruction, fancy digital expensive recreations, and they're both wonderful, and we use them both. They're great. But an eyewitness using the toys, the jurors in our focus group testings on the testing we have done preferred that method of evidence over the engineer talking through the crash reconstruction digital animation. And so I'll just give you some examples. You'll see that it's so simple. Here we're deposing a construction site superintendent. You can see the toys set up.
All right. What's the next warning sign?
1-lane road or be prepared to stop, either or.
Okay. I've got a 1-lane road. Would you put it out there?
Okay.
And is there a cone by it?
Yes.
All right. What's the next warning sign?
Flagger.
Is there a orange cone by it?
Yes.
And is this how you set it up on the day of the wreck, July 12, 2017?
Yes, sir.
And were you following the law that required a 1,500 feet advance notice of the highway work zone?
Yes.
Nothing fancy other than we're setting it up. And so jurors, witnesses can just set it up and feel it and see it. And here in this situation, we were able to set that up with the jury as well. And so we kind of had a debate on, do we hot glue everything together so that we can save time in front of the jury, or do we let the witness set it up again and give them a picture of what they'd done previously? This case resolved, and so we didn't have to go through that debate at trial. Okay, repeat after me, or I like to better say positive repetition. We're going to utilize our depositions to conduct positive repetition. For those of you who've tried a lot of cases, you know that repetition is important. We all know that. However, I'd go to a seminar like this, and I'd hear a great trial lawyer stand up and say, you gotta tell the jury repetition, repetition. You tell them again, you tell them what you told them, and then you tell them what you conclude, whatever. Positive repetition. Then I'd stand up and hear another great trial lawyer that I really admired say, no, juries, they get upset with you with too much repetition. They're smarter than you think. You should say it one time. And I was very confused for a long time until I realized they're probably both right. And so that's where I started applying positive repetition. Positive repetition is where we may show or share the same type of thing through different modes, through different visual aids, through different witnesses, but we don't say the exact same thing or show the exact same thing over and over and over. That becomes what I call despicable repetition. And you guys all know what I'm talking about. You guys know it. You have felt despicable repetition, every one of us in our lives, unfortunately, probably often. And so I hope I don't do it today. What we want to do is we want jurors to want to feel and see and hear what the evidence is. And because it's coming from in a different picture or a different drawing or a different animation or a different witness, it's received in a positive repetition manner. What are some examples of that?
Exhibit 29C. Is it your understanding that from the download from Martin's tractor that Martin's driver maintains a speed of around 65 miles per hour until 8 seconds before impact?
That's what the exhibits appear to show, yes.
Nothing fancy about that. We're taking very boring information, speed from a download, and creating an exhibit and a visual aid. What I want to show you here is that while we're talking about positive repetition, but this is the actual visual aid that's simply prepared ahead of time, marked with an exhibit, and used with a corporate representative. This was a video clip for trial. It's all done. And so, but here's the positive repetition. Here's another version of the same thing. So an engineer, obviously a crash reconstructionist, is walking us through this, but it's a different analysis, but it's the same data from a different approach. And so there's an example of positive repetition. Here's another way.
So in 29F, Martin's driver would have been violating the speed limit plus violating the recommended speed for that curve. True?
Mr. Gaynor would have been violating those, yes.
While driving Martin's tractor trailer. True?
Yes.
As a Martin employee. True?
Yes, he was an employee at that time.
Nothing fancy about this. I hope you're receiving these visual aids and saying, that's simple. That's what we really want to accomplish here today. And there's nothing fancy about the visual aid other than it was done and used in the deposition. And now the video clip is completely prepared for trial. And so you've seen three different versions of essentially similar evidence, but in a positive way, different visual aids and different witnesses. Positive repetition. Here's another example of positive repetition.
So on Exhibit 25A, Martin's driver Keith Gaynor in the state of Arkansas versus Keith Gaynor guilty plea, pages 8 and 9, lines 24 through 1. Keith Gaynor says, "So I was intoxicated and I was taking a turn too fast. I flipped my semi and it crushed a car and killed somebody." Do you see that?
I see that.
And are those the facts as you understand them?
Yes.
So really not worried about the content here. What I'm worried about is the teaching philosophy, in that this is positive repetition on one slide that is set up ahead of time because of our preparation to get the truck driver and the corporate representative on the same testimony in the same 30 seconds. So that's, I call it double positive repetition. And so we just have to do this once. Also, when we do something like this, we don't do it again with the truck driver. I'm not going to show that same thing. If we cover this testimony with the corporate rep, and I'm talking about a trial, not in deposition. We may cover it in deposition, but at trial, we're not going to then again use this exact same testimony with the driver. The jury's already received it, and so we're worried about
Exhibit 55.
to despicable repetition, which is what we don't want to do. I talked about standing up. If you remember, about 45 minutes ago, I talked to you about why we moved the chairs away from our side of the conference room table in the depositions, our trial courtroom. And that's so that I can stand up, or you can stand up and take the deposition. I would never suggest to you that you stand up the entire time at all, unless your back's hurting. But what I do is I just get up and go get an exhibit. I go get up and get a visual aid, and then we walk to the witness. And what I found is that for the same reasons that we usually stand up for direct or cross-examinations or opening and closing statements at trial, they work the same way in the deposition. It also breaks things up. I don't know how many of you have to take depositions that are hours long, but I have found that just everybody bogs down at 4 hours. And so standing up literally kind of wakes everybody up. It changes things, and it changes the angles, and it works very well. And there's absolutely no rule against it. Once again, I'll tell you the story. What created this is I was young and taking great depositions. Things were going well for us. And the defense bar in our little tiny state had kind of been talking about our deposition strategy. And so I generally have a way that I set up the deposition and the way that I handle exhibits and visual aids. And so I got to this is going to be 15, 20 years ago. I got to take down to the defense firm where they wanted me to take their corporate representative's deposition. I go up the elevator and I walk into the conference room, and on my side of the table are stacks and stacks of banker's boxes where I usually sit. And they're all down through there. And there's a chair at the far end of the table that's for me. And then the defense firm it was clearly law clerks and secretaries taking up all the other chairs. So when I walk in, there's one chair available for me. Of course, at first I was very upset by that. And so I had to go out in the hallway, and at first I was angry, but I prayed a little bit, came out of that, and I thought, oh my goodness, you know what? I'll just have a little fun with this. And so I stood up and took that entire deposition from the back of the room. And I did it because I was kind of forced to in this circumstance. It was a phenomenal deposition, and it was just like when I was in the courtroom and I was walking up, approaching the witness, taking exhibits up there, backing away, body positioning, body language. I was going back and forth, walking around, handing stuff to the defense counsel, walking up to the witness, getting in different spots. And I had so much fun that day because the defense lawyer did the dirty deed to us. And I left there, and on my 3-hour drive home that day, I was like, golly, I need to stand up for depositions more often.
Shortcuts challenging or negatively impacting nuclear, industrial, and radiological safety are not tolerated. Do you agree with that?
Yes.
So if there's a shortcut that negatively impacts nuclear, industrial, or radiological safety, supervisory personnel at Entergy should not take that shortcut. True?
I agree.
That would be an intolerable behavior. True?
The expectation.
Nothing fancy about that other than we're standing up and you're seeing us use the boards. That's the only point of that slide. I also want to visit with you about cadence, because we've heard about cadence in the courtroom forever. I've heard some of the best trial lawyers I've ever heard speak, just unbelievable, talk about cadence, even in a direct exam. You mostly hear it taught in a cross-examination in the well of the courtroom. And I believe in all of that wholeheartedly. And so I've heard it taught, and we were trying to do it and trying to learn how to do that in the courtroom, and all's wonderful. And then but how do I get cadence? How do I get rhythm? That's what I was trying to figure out. Well, as Phil mentioned when he introduced me, I've been trained as a live auctioneer. So I went to auctioneering school, I think in 2009, and had a great time. It was just a great experience. It expanded my mind. It taught me new things I've never been exposed to. But at auctioneering school, you have to learn about cadence and rhythm. And you have to do it with something that's kind of boring, numbers. And so here's how they taught us at auctioneering school, cadence and rhythm. They taught us to take our favorite song. Every student there picked their song and go sing the chorus line. So I picked I've Been Everywhere Man by Johnny Cash. You guys hopefully heard the song. If you hadn't, shame on you. Let me know. I'll send it to you. And you guys that know it, it's, I've been everywhere, man, right? And so you have to sing it. I've been everywhere, man. I've been everywhere, man. So then once you get that chorus down, then they have you plug in the cadence of the chorus line with numbers. I've been everywhere, man. I've been everywhere, man. $5 bid now 10, $10 bid now 15, $15 bid now 20. And the next thing you know, you've got cadence with numbers. And then you can speed that up, of course, or slow it down. Well, after we practice that every day for like 14 days in a row, everybody there, even folks who said they could not dance and had no rhythm, they had cadence. They had rhythm. It can be taught. And I'm driving back from Dallas, Texas, and it hit me. I had so much fun with this cadence and rhythm process. I was like, oh my gosh, I can do this in my next deposition. I can practice cadence and rhythm by getting my questions short, more concise, and I can get to rolling, just like I've heard great trial lawyers from across the country teach in the courtroom. We'll start doing it in depositions. And we started practicing it, and it works very well. You have to be organized. You have to have your questions succinct and as short as possible. But as you guys know, for the same reason it works in the courtroom, it works very well in depositions. Because what I want to do is just roll to the video clip, roll down with that cadence and rhythm. And if you need help with cadence and rhythm, you should buy some Johnny Cash music and listen to a Billy Graham sermon, because these two gentlemen are some of the best ever in history with cadence and rhythm. Actually, we do depositions, our trial workshops, and I have people pick their favorite songs. We then write out 3 questions, 3 to 10 questions, but I'll usually start them out with 3 questions on one of their cases. And then we take their chorus rhythm and have them do it with their 3 questions. It doesn't take people very long. In less than an hour, we'll have trial lawyers of every age using a little cadence and rhythm. Uphill language. I like to conclude here in my last few minutes with uphill language, because there's language that I hear us use on both sides of the aisle all the time that are just creating more obstacles for ourselves. Such as the most common is, you would agree with me. I hear lawyers use this, you'd agree with me, you would agree with me. Well, I don't know what kind of depositions you're taking, but most of the time, the person I'm deposing or the people or the entities I'm deposing, we filed a lawsuit against them. Or if you're on the other side of an aisle, that person perceives and believes you hurt them. And so if you're an adversarial attorney to the witness and you say, you'd agree with me, you start the witness out before they even hear the question, no, I don't. And what we want to do is we want to open up the window for the truth. That's our only goal here. Our methodologies work very well if your goal is to collect the truth. And what I have found is 80% of the witnesses that I depose, by the way, this is barstool science, 80% of the witnesses that I depose are good people, truth-telling individuals who want to tell the truth. They're good at their jobs, they're good husbands, they're good spouses, they're good parents, everything. And it's only the pressure of litigation that puts them in a situation where it's not that they don't want to tell the truth, they're just under pressure. Whatever that source of pressure is, I don't know. But what I found is that 80% want to tell the truth. And on those 80%, our methodologies work well to simply open the window to let the truth come out. That's all we want. Now, 10% of witnesses, they're going to tell the truth no matter what you and I do. Hallelujah for those witnesses, right? They're just going to, those are short depositions and it feels great. Your mind didn't have to work as hard that day. The other 10% of witnesses are going to outright lie no matter what you and I do. And you don't have to worry about those people because they're all going straight to hell. So, and what I've found with witnesses that are willing to outright lie, when those witnesses or entities get in front of a jury, the jury rings them up. So that's why I say our methodology works 100% of the time. The 80% that just need a little help to open the truth window, the 10% are going to tell the truth no matter what you do. And the other 10% are going to lie, play those lies in front of the jury, and it'll be the highest verdict you've ever received. Or if you're on the other side of an aisle, for me, it'll be a defense verdict if the plaintiff lies. We want to avoid or try to avoid I, me, and my in our questioning. Because if you're making this deposition about you, things aren't going to go good. That's all there is to it. The word correct is difficult. So I don't know. I'm not a big fan of the word correct at the end of our questions. So correct, correct. It's not just horribly wrong, but what I'll find is you've got to really make sure that your question, your load, that's what I call it, the load of the question is perfect, or the word correct can be a little confusing to the witness. All, every, and never. When I was young, I put those three words in every single question, every single, always, never question. And I was running into all these roadblocks with witnesses, just constantly roadblock, roadblock. Oh my gosh, what's the problem? There's something simple. It's like, well, the word all, every, never. And what I found is just take them out. The question is just as good and just as strong, and you don't have to put in those types of words. They're just going to create obstacles. Here's an example. It's a very simple example, but do you agree with me? Tractor trailers should have safe brakes on each axle. Instead, tractor trailers should have safe brakes on each axle. And I'm doing that with inflection, which we practice, or tractor trailers should have safe brakes on each axle. True? And of course, that's assuming a hostile witness in a cross-examination for a leading question. It's my understanding, once again, I hear this all the time. Matter of fact, I've seen this taught. It's my understanding that insert What I've seen happen with witnesses, adversarial witnesses, when you say it's my understanding, wait a minute. And so what we've said is so it's clear for the jury. So it's clear for the jury, Great White Logistics hires drivers with no felony convictions within 3 years of hire. True. And so there are things like this that create an easier path to the truth and simply removes you or me from the process. Now open it up, whatever questions you have, worst case scenario, I don't know the answer, but I'll do the best I can to honestly answer it. Thank you very much.
All right, yeah, so we do have some questions. The first one is in regards to your mock jury section. They were asking, do you worry about defense's discovery of your mock jury materials?
It's very possible. It is possible. And I've been worried about that before. I've had it happen before where defense found out and they did planted a juror spy in our mock trial event. And so it is very possible. I think that that's part of the risks. We try to do a background check on our jurors and they got to sign their life away, of course, and confidentiality and agree that that's not happened ahead of time. So we do things to try to prevent that. It is possible though.
All right, and let's see. This question is in regards to the first example you're using with the truck drivers with the character assassination. They wanted to know if you were using animations too in that particular deposition.
Animations too?
Yeah.
I don't understand the question.
I guess they're just curious if you're also using animations in your depositions. This was in regards to the one with the video that you were talking about that you didn't want to end up using.
Yes, we use animations in most of our depositions of some sort. It depends on every case is different, but we generally do show some sort of animation. I call it recreation. Animation, we've tested that. That's like a cartoon and it's not real. A recreation is real. And so we're going to use a recreation of some sort generally on almost every case, not every deposition, but strategically with witnesses.
All right. And then the next question is, they would like you to repeat what the mad factor is. I guess they're also curious as to what is almost always unanimously chosen among jurors. Was there a specific one, or was it all the ones that you mentioned?
That was a specific case example that I gave you. What I meant by is in every individual case that you test, let's say you've got 5 mad factors, pieces of evidence that upset the jury. What I'm telling you is that most of the time, the piece of evidence, the number one mad factor that upsets the jury the most is unanimous amongst your focus group members. So you and I would have to get together and talk about and list out and brainstorm what are the mad factors and then test it. And we'd find that the jurors are like, every one of them that makes us the most upset.
Great. And another question is, if you have a large stack of business records, do you have any more tips on making those interesting or more interesting when you must present them?
Absolutely. When you have boring information, that's why visual aids are even more important. And so we're going to do summary versions of it, but let's just say you've got 1,000 pages, right? Surely I'm praying you don't have to go through 1,000 pages there, but of the 1,000 pages, let's say you have to go through 150 of them in a deposition. And that's realistic sometimes. In that situation, we are going to have a visual aid created for those 150 boring business records, visual aids of it, blow ups, or if there's anything we can at all creatively attach to it as a photograph or an animation or a red flag. And then we're going to hand the original document to the witness. And then we're going to hand them, let's say the original document is Exhibit 1. Then Exhibit 1A is the visual aid of that document. And then we're going to repeat that so that it's simple, it works, and it is how we make something very boring a little bit more digestible or tolerable in how we go about it. The next thing I would tell you to do is how do you take those business documents and turn it into a story? That's what you really want to try to do. So boring 1,000 documents. Well, what's the 3-minute or less story of those documents? Then storyboard it. So you can pile up these documents, but let me tell you the story of these documents, ladies and gentlemen. Or let's get that story out through a series of questions from a witness and let a witness tell the story of these documents. And then if possible, usually in most cases, there's some photograph or drawing that we could, as the person tells the story of the documents, then those photographs or drawings pop up across the top as you tell the story. Now, every case would be different. There might be cases that are just so boring that you couldn't even do any of that. But most of the time, what we find, almost all of our cases, there's a way to take that big pile of documents and tell a story and create visuals for them.
Great. And then the next question is, what is the best way to gather a mock jury pool?
You know, I don't think there's a best way. There's so many ways to do it. I have done, I was much younger. I would go into gas stations and sit down at the little cafe area and start talking to them about the case. So that's how we got started. I have gone to local churches, give them $1,000 if 20 people would stay after church and hear about this case. Now, of course, we're more sophisticated and we hire headhunters now and we give them demographics because we're going to find out the demographics of our venue and we are going to duplicate as close as possible the demographics of our venue. And so we hire headhunters now for our focus groups and jury simulations to get that accomplished. I just don't want people to get, if you're not doing it now, don't worry about it so much as put an ad in the newspaper, put an ad on Craigslist, put an ad on YouTube, put an ad out there that you're going to pay $100 for a morning on a Saturday for 2 hours. You'll have people sign up. Now you have to vet them, of course, but you can also, an inexpensive is just calling a simple staffing agency and asking for 6 men, 6 women, or whatever you want to do. And so those are some ways of doing it. If you're wanting to get started, don't worry about it too much. Just round up a group of people and get started. If you're already doing it and you're ready to go more sophisticated, then I encourage you to set up a call with myself and Philip Miller, who's our jury consultant across the country, who we've done so many of these and gotten crazy results. And so he's the best I've ever seen at doing it. Philip Miller out of Nashville, Tennessee. And there are others who are awesome at it as well. He's just one of my closest friends, and he and I have been doing it since 2012 together.
All right. And let's see. So, what apps or media do you use for deposition visuals? PowerPoint, still photos, videos?
All of the above.
All right.
We're using everything. I mean, that's it. We're using everything, and I'm constantly challenging my team to be more creative and try new stuff. So when we do try new stuff, like new visuals or new animations, we don't do the entire deposition that way. Like we'll stick to what we know, which is primarily PowerPoint, quite frankly, videos, pictures. But if they've got a new idea, then we'll bring in 3 new ideas, not 100, into the next deposition. Test it out. I'm also a big believer in what they call paper, Sharpies, glue, crayons, butcher pads, Hobby Lobby, 2x4s. If you've seen our trials, we have a 2x4 timeline where we put a 2x4 in front of the jury, put dowel rods in it for our chronological timeline. And so we're big believers in all of those things. And of course, I love playing with toys.
All right. I think that about wraps up Q&A. So, Mr. Oliver, thank you so much for your time today. The presentation was fantastic, and I hope our attendees enjoy the rest of their afternoon. Thank you so much.
Thank you all. Bye-bye.